This paperwork appears to be a Presence Investigation Report, PSR, for an individual named Talvin Lamar Brandon, detailing his involvement in drug trafficking and related criminal activities. The document includes statements from cooperating defendants, CDs, sources of information, SOIs, and other evidence that outline the roles of Brandon and his associates. To determine who snitched, we need to identify the individuals who provided incriminating information to law enforcement about Brandon's activities. Let's break down the key sections and analyze the information. Key sections of the paperwork, header and overview, top of page 16. Defendant, Talvin Lamar Brandon. Charges, Brandon and his conspirators, including individuals referred to as CD1, CD2, CD3, etc., were responsible for distributing multi-kilogram shipments of cocaine and heroin across multiple states, including Massachusetts, Colombia, New York, the Dominican Republic, Puerto Rico, and New Jersey. Timeline. The conspiracy spanned from September 2022 to July 2023. Drug quantities, 135,000 grams, 135 kilos of cocaine, 15,000 grams, 15 kilos of fentanyl, 2,000 grams, 2 kilos of heroin. Key associates, Oakley, a major player in the drug trafficking operation. Cordova, another key figure, often working with Oakley. Additional details. Oakley received drugs from New York and New Jersey sources and distributed them in North Carolina. Oakley stored drugs in Youngsville, North Carolina, and later in Raleigh. Brandon was identified as a customer of Oakley, purchasing 2 to 3 kilograms of cocaine every 2 weeks. Paragraph 55. Additional statement from CD1, August 30th, 2023. Source, CD1, a cooperating defendant. Statement, CD1 stated that Oakley had approximately 1,500 grams of cocaine from various sources. Analysis, CD1 is providing specific information about Oakley's drug supply, which indirectly implicates Brandon since Brandon was a frequent buyer from Oakley. CD1 is likely snitching on Oakley, and by extension, on Brandon's involvement. Paragraph 56, statement from CD3, May 1st, 2024. Source, CD3, another cooperating defendant. Statement, CD3 was paid $10,000 by Cordova to deliver narcotics to CC11, a contact in North Carolina. CD3 delivered 15 kilograms of cocaine, 8 kilograms of Oakley's cocaine, 5 kilograms of heroin, and 4 kilograms of cocaine-heroin mix. On July 18, 2024, CD3 met with Cordova in Teaneck, New Jersey, to pick up money for Cordova's house in Durham, North Carolina. CD3 instructed Oakley to deliver drugs to Cordova in New Jersey. Analysis. CD3 is providing detailed information about their own role in the conspiracy, as well as Cordova's and Oakley's activities. This directly implicates Brandon because Brandon was a customer of Oakley. CD3's cooperation with law enforcement makes them a snitch in this context. Paragraph 57, Brandon's role in injury. Details. From March 2023 to July 19, 2023, Brandon possessed 20 kilograms of cocaine and was involved in drug trafficking. On October 24, 2023, Brandon was shot in the arm, leading to a serious injury. Brandon claimed the shooting was related to a drug debt, but the United States Probation Office found no law enforcement role in the incident. Analysis. This section doesn't directly identify a snitch, but provides context about Brandon's involvement and the risks he faced, which may have been exacerbated by others cooperating against him. Paragraph 58. Defendant statements, admissions. Statement none. Analysis. Brandon did not provide any admissions or statements, meaning the incriminating information about him likely came from others, e.g., CDs or SOIs. Paragraph 59, victim impact, statement. These are Title 21 offenses, drug-related, so there is no identifiable victim. Analysis. This section is not relevant to identifying a snitch. Paragraph 60, juvenile adjudications, statement none. Analysis. Brandon has no juvenile record, so this section is not relevant to identifying a snitch. Paragraph 61, adult criminal convictions, details. Brandon has prior convictions in North Carolina, Granville, and Vance counties for minor offenses like no seatbelt, no operator's license, and speeding. These convictions are not scored under the U.S. Sentencing Guidelines, USSG. Analysis. This section provides background on Brandon's criminal history but does not identify a snitch. Paragraphs 62, 63. Criminal history computation. Details. Brandon's criminal history score is 0, placing him in criminal history category 1, the lowest category under USSG. Analysis. This section is about sentencing calculations and does not identify a snitch. Paragraph 64. Other criminal conduct. Statement: none. Analysis. No additional criminal conduct is noted, so this section is not relevant to identifying a snitch. Paragraph 65. Pending charges. Statement: none. Analysis. Brandon has no pending charges, so this section is not relevant to identifying a snitch. DEA Form 6A, page 4 of 6. Source: Source of information, SOI. Statement: the SOI stated that Oakley, known as Taz, supplied 2 or 3 kilograms of cocaine to Brandon every 2 weeks for 5 to 6 months. The SOI identified Brandon as Taz using a photo. Analysis. The SOI is directly implicating Brandon by identifying him as a frequent buyer of cocaine from Oakley. The SOI's cooperation with the DEA, including identifying Brandon via a photo, makes them a snitch in this context.